അങ്ങനെ ചെയ്താൽ
അപ്പോ
അതുകൊണ്ടൊരു ബെനിഫിറ്റ് കിട്ടില്ല. അതുകൊണ്ടാണ് ഞാൻ സ്റ്റാർട്ടിലെ പറഞ്ഞത് ടേക്ക് 6 or 7 classes and I may not be able to come every week, but once in a month I shall try my and moreover that if I get time, definitely I will come, don't worry. I will go sir, and definitely I will come, but due to my time deficiency, so otherwise I am very interested to താല്പര്യമുള്ള വിഷയമാണ് ക്ലാസ് എടുക്കുക എന്നുള്ളത്. For the last more than 39 years experience as a teacher. അതുകൊണ്ട് നമുക്ക്
ആരെങ്കിലും വിളിച്ച് ഫോർമൽ വെൽക്കം സ്പീച്ചിന് വേണ്ടിട്ട് ആരെങ്കിലും വിളിക്കാം.
വെൽക്കം ഒന്നും വേണ്ട സാർ, അങ്ങനെ തുടങ്ങാം.
അല്ല, ഇന്ന് അങ്ങനെയാണെങ്കിൽ നമുക്ക് ഒരു കാര്യം ചെയ്യാം. പിന്നെ ഇപ്പൊ സാറ് നമുക്കിപ്പോ ഇത് നമ്മളെ 3ാമത്തെ ക്ലാസ് ആണ് സാറിന്റെ ഭാഗത്ത് നിന്ന് കിട്ടുന്നത്. ഏതായാലും 47ാമത്തെ സെഷനാണ് ഇന്ന് നടന്നുകൊണ്ടിരിക്കുന്നത്.
3ാമത്തെ അല്ല, this is the 5th class.
അത് സാറിന്റെ 5ാമത്തെ ക്ലാസ് ആണ്.
സ്പെസിഫിക് പെർഫോമൻസിന്റെ അത് സാർ എടുത്തു. ഇതിപ്പോ നമുക്ക് കണ്ടിന്യൂസ് ആയിട്ട് നമുക്ക് പിന്നെയും ഇനിയും നമുക്ക് തുടരണം. അപ്പൊ സാറ് എനിക്കറിയാം, നമുക്ക് ഓൾ കേരളയിൽ തന്നെ ഒരുപാട് തിരക്ക് പിടിച്ച സമയമുണ്ട്. ഒരുപാട് ക്ലാസ് എടുത്തുകൊണ്ടിരിക്കുന്നു. ഒരുപാട് സ്റ്റുഡൻസ് ഇപ്പം സാറിന്റെ കീഴിൽ ഉണ്ട്. അതിൽ ഒരുപാട് സ്റ്റുഡൻസ് ഇവിടെ വന്നിട്ടുണ്ട്. ഇപ്പോൾ ഓൾ ഇന്ത്യ ലോയേഴ്സ് യൂണിയന് വളരെ സന്തോഷമുണ്ട് സാറിനെ പോലെയുള്ള ഒരു എക്സ്പേർട്ട് നമുക്ക് ഇങ്ങനെ ഒരു ക്ലാസ് എടുത്തു തരുന്നതിൽ. അപ്പോൾ സാറിനെ ആദ്യമായിട്ട് സ്വാഗതം ചെയ്യാം. അതുപോലെ കേരളത്തിൽ അങ്ങോളം ഇങ്ങോളം ഇപ്പം ബാർ കൗൺസിൽ അംഗങ്ങൾ ഷർഫുദ്ദീൻ വക്കീലുണ്ട്, അതുപോലെ ലതാ തങ്കപ്പൻ GP ഉണ്ട്, സീനിയർ ആയിട്ടുള്ള ഒരുപാട് പഴയ നമ്മളെ റിസോഴ്സസ് ആയിട്ടുള്ള ഗിരിധർ ഉണ്ട്, അതുപോലെ PG സുരേഷ്, ഒരുപാട് ആൾക്കാരുണ്ട്. അതുപോലെ പുതിയ ഒരുപാട് സ്റ്റുഡൻസിനെ ഇന്ന് കാണുന്നുണ്ട്. അപ്പൊ എല്ലാവരെയും നമ്മൾ സ്വാഗതം ചെയ്യാണ്. എന്റെ ക്ലാസ് എടുക്കാൻ വേണ്ടിയിട്ട് വിജയകുമാർ സാറിനെ ക്ഷണിക്കുകയാണ്.
താങ്ക് യു വിനോദ് സാർ. ആൻഡ് anyway, today is our second class on class 1B. In our last class, we have seen what is the definition of a bill and what is the object behind a bill is being executed, and how a bill is executed, what are the procedures to be followed, and also we have gone through different types of bill. That is, there are important 2 types of important bill, that is privileged bill and unprivileged. All those we have seen in our last class. That is the first part of law. Today we are going to see what are the effect of attestation by interested person, or effect of attestation by the person who is getting property or share in the estate, and what are the procedures to be followed for the alteration of will, how a will is being altered, and how a will can be revoked, and what are the principles to be followed by the court when there are consistent clauses in the very same will. All those things we are going to see today. And now one of the most important point with respect to we can watch in the case of will, that is when a case of will comes to a lawyer, normally suppose we are appearing for the plaintiff or whether we are appearing for the defendant, normally we will think only on whether it is properly attested and whether the witness is competent to depose before the court as the execution of the will, and whether the person who executed the will was competent and having good health at the time of mental health and physical health at the time of execution of the will. or we will concentrate on all those things. But when we go through the provisions in detail, we can see that not only that also are very important, but not only that, some other aspects are very important. For example, suppose tomorrow a defendant comes to you and he is appearing, he is a defendant in a case with respect to will. And when we go through the plaint averments, and when we go through the copy of the will, we can see that some part of the property has been disposed in favor of the attesting witness also. Then at that time, what we will think? Normally, we will think that the will is, so suppose attester, the person who has attested the will has got a share in the property by way of that will. And in such case, what we will think? Normally, we will think that that will is not valid. This may be the general thinking, but you see, such a will is not void, such a will is not invalid. It is valid. It is valid, even though it is attested by one of the attesting witnesses who has got some share in the property. That will is valid. But what is not valid? The share which is given by way of will to that witness, that alone is void. The share which is given to that witness by way of will, or share that is given to wife of that witness, or husband of that witness, or children of that witness, that portion alone is void. That means even if an attesting witness who has obtained some share in the property by virtue of the will, that will not be void. Only share given to the witness will be void. So that is clearly stated under section 67. Section 67 of Indian Succession Act clearly says a will shall not be deemed to be insufficiently attested by reason of any benefit given either by way of bequest or by way of appointment to any person attesting it, or to his, her husband, etc. But such a bequest shall be void so as concerning that attesting person. So that is very clear. That means suppose so section 67 clearly says such a will not be void on the ground that attesting witness has got some share in the property bequest given by way of will. And now we come to another interesting question. That is a witness who has attested the will cannot be disqualified on the reason that he has got interest in the estate bequest. He has got some share in the property which is given by way of will. That is clearly stated under section 68 also. So we may read both section 67 and 68 together. Both are saying that a will may not be invalid, or a will cannot be considered as not insufficiently attested on the ground that a share is given to the attesting witness, or some interest is being given to the attesting witness, but the share given to witness or interest given to witness will become void in such case. That means such a witness can be examined before the court to prove the will, and we need not worry with respect that, oh, this person has obtained some share, this will is going, this will not stand, this cannot be standing. No, don't worry that. Because section 67 and 68 is very clear. And on that point, KLT 2017, KLT 2017, volume 2, page 1084, Lisama versus Sarama. Lisama versus Sarama. Merely for the reason that, a beneficiary, under a will who has attested the will, that document will not become void. That document, that will not become void, but the attesting witness will not get the share or the right as per the will, because such a bequest to the attesting witness shall be void. As far as he is concerned, as far as that attesting witness is concerned. Okay, then another question arises. Suppose an attesting witness who has obtained a share, then presumption is that the bequest given in favor of that attesting witness as a beneficiary, that is void. Here, can it be rebutted? Suppose in a particular case you are appearing, and in that will, witness has given some share by way of that bequest, and the attesting witness is a beneficiary. And how can we contest? Section 67, 68, okay, but it can, such a presumption can be rebutted also. That means even though we can contest before the court that even though he has attested, and that share was given by way of some other thing, that you have to establish before the court. If you establish it, you can get over the bar envisaged under section 67 and 68. That is held in KLT 2006, volume 4, page 991. 991, Jos versus Housing. The presumption that a legacy to an attesting witness is void under section 67 and section 68 of Indian Succession Act. But such a presumption can be, rebutted. Such a presumption can be rebutted by establishing that such a presumption can be rebutted by establishing that he had signed the will. He has signed the will not as an attesting witness, but acknowledging his obligation he has to discharge under the will. Acknowledging obligation he has to discharge under the will, or he can prove before the court that share is given to him. Share is given to him not as an advantage for attesting the will. Not as an advantage of attesting the will. So here we can see that attesting witness who can obtain property, and that part alone is void, and in all other cases that will is valid one. It cannot be said that. So that is the point with respect to when attesting witness is getting a share in the property where the legacy is bequeathed as per the will. And now we are going to see another important point, whether a will can be revoked. Normally we may be having a thinking that suppose a person who has executed a will and subsequently he is executing another will, the last will prevail. That is a general principle we all know. Suppose A has executed one will in 2015 and in 2019 he executed another will, and in 2020 he died. The person who executed the will has expired. Then which will prevail? Second will prevail. Subsequent will prevail. But in that case, so this is one of the methods of revoking the will. This is one of the methods of revoking the will, one of the way. But that doesn't mean that Second will prevail. We cannot say that. Okay? We cannot be sure that second will prevail. So now we are going to see what are the circumstances, what are the situations under which a will can be revoked. Then one important ground for revoking a will is marriage. Marriage is automatically revoking a will. That means suppose a person who has executed the will, who is not married, and after executing that will, he got married. When he got married, automatically that will be revoked. And I need not explain the reason for that, because that is that section 69 of the Act clearly states due to the marriage. So the object behind that section is to protect the wife and children. Because for example, suppose a person who executed the will and he got married, and he having 2 or 3 children. After that he expires. Then what will happen? If that will is existing, if that will is becoming valid, what will be the condition of the wife and children? So by knowing that situation, our parliament has incorporated section 69 to provide a marriage as a reason for revoking the will. And one exception is also there. Section 69 is very clear, and one exception is also that. But in a will, the testator is making an appointment of his executor or his administrator, whatever may be. So that alone is done. That may not be void. Except that means suppose I can execute a will. If I am not married, I can execute a will, and in that will I have stated only the administration of my estate. That means I have appointed one person as my executor to manage the property after my life, or to administer my property after my life. That alone is valid. That alone is valid with respect to a will executed by a person who is not married. And in all other aspects, the marriage is revoking the existence of a will. That is clearly stated under section 69. And 69 and 70, these are the two provisions under Indian Succession Act providing revocation of will. And now we come to section 70. Section 70. So before that, we may be keeping in our mind another important point. Suppose a defendant who comes to you, or suppose a plaintiff who comes to you. That means a person who comes to you with a will. Tomorrow he is coming to you and say that, sir, some person who has executed a will in my favor, and as per that will, I have obtained this much of the property, but some of his relatives are not allowing me to enter into the property. Sir, you may do something. And one more point he is highlighting you, that is, sir, on the will with the reading, he has written before his death. He has written cancelled on all the pages of the will with the reading, or whatever may the color of the ink. He has written cancelled. Then what will you do? Normally what we will do, or sometimes if you don't know, if you don't know this point, what will happen? We will ask him, hello, this is very difficult because before his death, he has cancelled it. Before his demise, he has cancelled it. Then once it is cancelled, it will not stand. No, no, because settled possession is that. So revocation of will should be done as envisaged under section 16 and 70. What 70 says? What 70 says? He is executing another will. That means a subsequent will. So when he is executing subsequent will, the first will go. Or he is executing another codicil. Codicil means a document which is amending or correcting the will. And he is executing a codicil stating that he has cancelled that will. Or by some writing declaring the intention to revoke the same. Or by burning it, or by tearing it, or otherwise destroying it by the testator before his death. And one more point, when he is executing another will, or when he is executing a codicil stating that he is revoking the will, or he is writing something declaring that the first will is revoked, all those documents should be attested as a will is being attested. That is very important. Simply writing on the top of the will or on the cross of the will with a reading cancelled, it will not invalidate a will. That is important. Such a will not be void one. Such a will is valid one. If you prove other, that we will discuss in the last class of this law on will. So here the interesting thing we have to see that suppose a person who has executed a second will, which will be prevailed. So that is the point I am inviting. I am inviting your attention to that point. Suppose one person executed a will and stated every property that is going to be, and before his demise, he has executed another will, giving the property to D. First he gave the property to A. Secondly, by way of second will, he gave the property to B. Then which will prevail? Which will prevail? That means the will which is being proved before the court. The will which is proved before the court. Due attestation of the will is proved. That will prevail. That means a will can be revoked by executing subsequent will. That's okay. But that subsequent will should be proved. Attestation should be duly proved. Then only we can say that first will was revoked. Second will is prevailing. But on the other hand, suppose second will is not duly proved. What will happen? Second will is not proved. Attestation is not proved. What will happen? Definitely, first will prevail. So these are the all situations under which a testator can revoke the will. Apart from this, what stated under section 69 and 70, apart from that, there is no other reason, no other ground, nothing can be taken as a will is revoked. That is very important. So why I say this? Why I say this? I have conducted a case. So that was come to me after going to 2 or 3 lawyers. What happened on the will? What I said earlier, on the will with the reading, it is clearly written. This will is cancelled. Okay. So that is why other 3 lawyers they did not take the file, thinking that the matter may not be succeeded. That may be the reason. Maybe the reason. But when it came to me, I took the matter and filed the suit, and I got the property also. And finally, the matter was settled in between the parties. Anyway, because of that case. So, the important point we have to keep in our mind, that is, a will cannot be revoked otherwise than as mentioned under section 69 and 70. In all other aspects, the first will prevail. And on that point, KLT 2019 volume 2, KLT 2019 volume 2, short note 12, baby versus Jacob. Baby versus Jacob. Requirement of manual destruction of will. Requirement of manual destruction of the will is not applicable. So far as not applicable, so far as a registered will is concerned. A registered will is concerned. And such a will cannot be revoked. Such a will cannot be revoked by way of burning it. So this is with respect to registered will. Registered will should be revoked by way of another registered document. Otherwise, such a will cannot be cancelled. But another important point. See, another question, interesting question that I am putting before you. That is, suppose a person who has executed a will, and that was being registered. A will that was being registered, and that is that after 2 or 3 years before his death, he executed another will that is not registered. First will is a registered one. Second will is not registered. And after that, he died. Which will be prevailing? Whether registered will or not registered will? If the second will is proved, the second will, even though because registration of will is not compulsory, as per section 17 of Indian Registration Act, it is not a compulsory registrable document. Will need not be registered. Be registered also. That alone can be registered also. But even if it is registered, that should be proved under section 68 and 69 of Indian Evidence Act. That we will see in the last session of this class. So here what happened in this decision, the court held that if the document is registered one, that should be revoked only by way of another registered document. But when we read that judgment entirely, it is also discussed that even though that is not registered, but it should have been executed as per the due attestation. So it should be duly attested. That is main important point. As far as a will is concerned, a will should be duly attested. That alone is the requirement. If not duly attested, it cannot be accepted. That is why it is clearly stated that simply writing across the will cancelled, it will not stand. And another decision, that is KLT 2007, KLT 2007. Volume 4, page 853, Joseph versus Appunni. If there are two testaments, the last testament will prevail. Last testament will prevail. But if the last testament fails, the first one will prevail. So this is one of the important point with respect to revocation. That means so second one is executed by revoking the first one, but the second one is not proved. It is proved that it is not duly executed. So there is no second one. That means he has not revoked the first one. That is a material point with respect to revocation of will. And another point, KLT 2005 volume 3, KLT 2005 volume 3, page 63, Pappu versus Kuti. Execution of second will. Amounts to revocation of earlier will. But execution of second will should be proved as duly executed. Execution of second will should be proved as duly executed. Then another important decision that also may be recorded, that is KLT 2001, KLT 2001, short note 63, KLT 2001, short note 63, Ravindran versus Valsala Devi. Ravindran versus Valsala Devi. In the case of revocation of a will, in the case of revocation of a will, mere writing cancelled or drawing red line across it, drawing red line across it, are not sufficient, are not sufficient. Okay, so now we have seen revocation of unprivileged will. Section 69 and 70 deal with the revocation of unprivileged will. Now we are straight away going to, without going through section 71, we go to section 72 because that is also with respect to revocation. That revocation is the revocation of a privileged will. After that, we will come to section 71. And how a privileged will is being revoked. In the last class, we have seen what is privileged will. Very interesting. A soldier or Navy officer at the war front is orally stating with respect to disposition of his property, that is more than sufficient as far as a soldier is concerned at the war front. And also we have seen that if he come back within 1 month, if he come back within 1 month, that will not stand. That also we have seen. All those are with respect to privileged will. And here, how a privileged will can be revoked? That's a question. How a privileged will can be revoked? A privileged will can be revoked by way of executing another document or will as a unprivileged will is being executed. That is important. So suppose there is a privileged will, that will can be cancelled, that will can be revoked by executing another will as a unprivileged will is being executed. That is important. Privileged will can be revoked by executing another will. That is in the case of unprivileged will. That means it should be duly attested. It should be duly attested. That is as per section 72. That also we should keep in our mind with respect to revocation of a will. And now another important point we are going to see. Now we have seen revocation of will, how it is being revoked, and what are the circumstances it can be revoked, etc. We have seen. Now, another important question that may arise before us: whether a will can be altered. Alteration of will, how it is possible? For example, suppose a case in your hand, a case in your hand. So after this, we may read when we get get a case of will. Definitely, we will go through everything. After knowing all those things, you know everything. But when we are gone through in detail, we will be very cautious whether we are appealing for plaintiff or whether we are appealing for defendant. And here the question is, with respect to alteration of will, how a will is being altered. For example, suppose in a particular case in your hand, in the particular will in which you are appearing for the plaintiff, in that will there is an alteration. What alteration? Alteration was with respect to extent of the land. Extent of the land. That means originally when he executed, it was stated that it was only 15 cents of land. And after that, some alteration was done. That means in the place of 15 cents, it was changed to, in the place of 15, 5 zeros added. Originally it was 15 cents, but in that place, 50 cents was included. So that was the alteration. How it is valid? Whether simply writing by the very same testator before his death. Because when the dispute comes with respect to will, then testator will not be here. That is why we are discussing will in detail. That is the importance of law of will. So here that alteration was with respect to, in the place of 15 cents, 50 cents is incorporated, altered. And whether that alteration is valid? Simply making alteration will not be valid. When a will is being altered or when a will is being obliterated or some interlineation is made in a will, that alteration or obliteration also should be duly executed. That means testator should have signed it and witnesses also should have attested it. Due attestation is also important. And that is why we are making the codicils. Or it can be that that is dealt under section 71. Section 71 is very clear. And in such a case, in the case of alteration, attestation can be made on the margin of the document. That also can be done. Need not be attested at the end as in the case of original will we are doing. No need of that. It can be done on the margin. That testator should have signed it and the witnesses also should have attested it. That is the case of alteration of a will. So if you have got a case at present, if you definitely you should go through any alteration. So that means I have got an experience. That is why in a case I was appearing for a defendant, and this was the claim. Very same claim was there. In the place of 15 cents, 50 was added. That was clear alteration. And no, not attested. Not attested because it was so, when, as per section 71, when alteration is done, that should have been duly attested. So it was not there in the will. I have pointed out the example in my own case. That is happened. Then what happened? Only 15 cent is given as per the will. Will is proved. Okay. In that case, will was proved. But 15 cents was given. Only 15 cents was given by the court. The court was not able to grant 50 cents because alteration was not duly executed. So we should be very careful. We may read. So that is why in the beginning of today, I said normally when will case is coming, we will be mainly concentrating on whether duly attested. We will not go through corrections, etc. So we should go through that also. Corrections, suppose it is executed registered one. So document writer may be there. In other case, not registered document, not registered will. This may happen. Corrections. So when corrections are there, when we are appealing for the defendant, we can attack on that point. Because corrections, so when corrections are there, normally it may not have attested it. So section 71 is very clear. It should be duly executed, and that can be in the margin also. And on that point, you may take a Supreme Court decision, that is KLT 2011 volume 4, KLT 2011 volume 4, short note 112, short note 112, Supreme Court, Dayanidhi versus Rukma. Dayanidhi versus Rukma. Section 71 of the Act. Section 71 of the Act is very clear. Is very clear that any alteration made in an unprivileged will, any alteration made in an unprivileged will after its execution has no effect unless such alteration has been executed in the same manner, a will is executed in the same manner, a will is executed. The proviso of section 71 is also very clear, that such attestation can be made in the margin of the will, So this is very important. How a will is being altered, how a will is changed, or how a will is corrected, etc. That also should be in the due, in the form of due execution, and it also should be duly executed. And now another important question is arising before us. That may be the last point of this chapter 5. That is the last point. That means suppose a will is revoked. So he made a document revoking the will. Here the question is whether a will can be revived, whether a will, once the will executed, thereafter it was revoked, and after that he is making a revival document. Can it be done? That question is being dealt under section 73. Section 73 of Indian Succession Act is very clear that a will can be revived in the same manner as execution of an unprivileged will. That also, execution is very important. That also, and here another important point is coming. That is, suppose a person has executed a will. A person has executed a will. After that, he revoked part of the will. He revoked part of the will. And thereafter, he executed another document revoking the entire will. First he revoked a part of the will. Then thereafter, he made another document revoking the entire will. And after that, he is making a document reviving the will. He is making the document reviving the will. In such a situation, the revival will be effected only with respect to the first part which he revoked first. That alone can be revived. That means in the case of revival, if he wants to revive both one, he has to execute 2 revival documents. So that is why, that is clearly mentioned under section 71. That means section 71 says, no unprivileged will or codicil, nor any part of which has been revoked in any manner, and shall be revived otherwise than re-execution thereof, or by a codicil executed in the manner thereof required, and showing an intention to revive the same. That is very important. He should show his intention to revive it. And when any will which has been partly revoked, so that is important point. If a will which is partly revoked and afterwards he fully revoked and thereafter it is revived. So firstly one part is revoked, secondly entire will is revoked, and thereafter he is making a revival. In such a revival, it shall not extend the revocation of the whole will. Revival will not extend it to the revocation of the whole will. That means in such a revival, only the first part he revoked first, will be revived. Unless an intention to counter is shown by the will or codicil. That is except in the case of an intention is mentioned by way of another codicil or by way of another will. In all other cases, this is the method of reviving a will. That means one point is very important. In almost all cases of alteration or revocation or revival, due execution is important. And intention is also very important. How intention will be proved? Intention can be because he will not be here. At the time when the matter is in dispute, the party who made the intention will not be here. Then how we will prove the intention? We will prove the intention with some other surrounding facts. That is important. Other surrounding situations we will bring before the court. That is Supreme Court said in 1994. In 1994, SEC 1994 Volume 1. SEC 1994 Volume 1, page 25. Kahar Singh versus Malik Singh. Kahar Singh versus Malik Singh. Intention of execution, revocation and alteration of a will should be proved by the surrounding circumstances and other witnesses. In the case of execution of second will, if there is a suspicious circumstances, in the case of execution of second will, if there is a suspicious circumstance existing, that should be dispelled first. That should be dispelled first. Otherwise, first will prevail. First will be prevailed. And one more point, that is AR 1977 Supreme Court. AR 1977 Supreme Court. AR 1977 Supreme Court, page 74. Jaswant Kumar versus Amrit Kumar. In the case of revocation of a will, in the case of revocation of a will, the testator should have done it. The testator should have done it with the intention of revoking it. With the intention of revoking it. Such a revocation should be in the manner as of execution of a will, and it should comply all the requirements under section 70. All the requirements under section 70. Okay, so now we have completed the revocation, alteration, and the obliteration, etc. And also we have seen whether any advantage given to attesting witness will adversely affect the will. That also we have seen. It will never affect the existence of will, but it will affect the share given to the attesting witness. All those things we have seen. And now we are going to see the verdicts. Verdicts of, that is also very important. Verdicts of how words are used. Whether it is mandatory to use hypertechnical words in the case of a will, as we are seeing in the case of sale deed, as we are seeing in the case of other compulsory registered document, etc. Whether all those technical words are essential in the case of will? No, no need of that. Why? Because it is written by, a will is being written by an ordinary person. Will is being written by an ordinary person, a simple man. He do not know the technical words, or he do not have other technical knowledge with respect to the words as used by lawyers or as used by document writer. So here section 74 is very important with respect to will. That means it is not section 74 clearly says it is not necessary that any technical words or terms or art to be used in will, but only that the wording be such that intention of the testator can be known there. So that means a simple man, a humble man, an ordinary man who testates, who deposes, his intention is to dispose the property before to make arrangement with respect to his property. And for that, he is going to make a bequest. and he is going to make a document. In that, the language he knows, that alone can be used. No need of other words as used by Rokun reflection. So that is the first point we have to keep in your mind when we are relying on the case of the Jew. That means that so the object behind that is no need of when you the court, you know that when we cross-examine the proponent, when you cross-examine the beneficiary before the court, we will we will try to destroy him. We will try to defeat him by asking different questions. At that time, when we put questions in the cross-examination, so as to defeat a will, so as to destroy a will, sometimes the court will interfere. Why you are asking? Because he is this, after all, this is written by ordinary man. Only simple words are used, but we will not leave him. We will process it as strong as we can. That may be the method of our cross-examination in almost all places. So that is entirely different. Anyway, so when we do that, we should keep in your mind section 74. Section 74 is very clear, and on that point, you may take two more decisions. That is KLT 2017 Volume 2. KLT 2017 Volume 2. 2105. 2105. Supreme Court. Palaniswamy versus Hindu community. Palaniswamy versus Hindu community. Intention of the testator is revealed through a testamentary disposition. And such an intention has to be found out. From the actual words used in the will. Court has no right to ignore. Court has no ignore clear words used in the will and add something to dilute the clear intention of the testator. Clear intention of the testator. So this is the position. That means what clearly stated in plain language, ordinary language, in his own language. That alone is required. that should be considered by the court. Court has no right at all to interpret in its own way, to interpret in its own view. So court has no right at all. And on the very same point, another decision also that is held in KLT 2010 volume 2, KLT 2010 volume 2, page 139, Supreme Court, Dilip versus Maharashtra trustee. Maharashtra trustee. Court should not more hyper technical. Court should not more hyper technical to interpret the hyper technical to interpret the contents of the will. Contents of the will. It should be taken as a the words and intention of an ordinary simple man. Ordinary simple man. So this is the position when we are going through the words used in the will executed by a person. And another important point, so now we are in the court. So why I say this, normally in case like this, with respect to will, court may be making interference and court may be making comments with respect to the words used, or court may try to interpret in its own way, etc., etc. In such a situation, we can humbly state before the court, because section 74 is very clear, only simple word that allowed, because that is the way to understand the real intention of the testator who executed it. That is why section 74 is incorporated. It should be in simple language, no hyper technicalities, no technical words, etc. Because an ordinary man may not know such wordings. And now we are coming after the wordings. Now we are coming the duty of the court to have an inquiry with respect to the questions which is related to the property and beneficiaries and the nature and circumstances of the testator at the time when the will was executed. All these are the duty of the court, to have an inquiry with respect to that. That means it is the duty of the court to have an inquiry when a case of will is coming. It is the duty of the court to have an inquiry with respect to what is the extent of the property, what is the nature of the property, what was the circumstance What was the circumstance under which that will was executed? What was the life of the testator at that time? And what was the circumstance and nature and life and relationship, etc., are of the beneficiaries in favor of whom that will is propounded. And also, it is the duty of the court. That is why section 75 is clear. That is, for the purpose of determining, this section 75 is very clear. The purpose of determining question as to what person, what property is denoted by words used in the will. The court shall inquire into every material fact relating to person who claim to be interested under such will, the property which is claimed as a subject of disposition, the circumstances of the testator and his family, and into every fact a knowledge of which may conduct to the right application of the words which the testator has used. So all those things should be acquired by the court in a case which is coming before it on the basis of that inquiry is very important. That means because of the reason is because testator may not be coming, and there may be some suspicious circumstance which has been clouded over the existence of the will. Everything may be clouded. So that is the duty of the other side. So when appearing on the other side for defendant, in the case of will, what is the duty of the defendant? What is the duty of defense lawyer? To create clouds. Create clouds. Because there is no chance of executing such a will. There was no such circumstance also. All those, so by making all those things, our defense, duty of defense is to create clouds, create suspicious circumstances. And once such a suspicious circumstances are created, or once such a suspicious clouds are created, then onus is on the plaintiff to remove all such suspicious circumstances. That means it is the duty of the plaintiff to answer all those suspicious circumstances. So that means, so that is very important. So see, suppose a plaintiff who has come to the court with a case, and plaintiff is bringing one of the attesting witnesses, and he was examined. That is okay, clear. And believing that he has clearly proved, that means he examined the propounder. He examined the propounder first, then he examined one of the attesting witnesses, and that execution is proved, due attestation is also proved, etc. And at that time, by way of cross-examination by the defendant should have brought some suspicious circumstances over the clear sky of your will. Such a suspicious circumstance or suspicious clouds that is covered over your clear sky of the will, that is your duty, plaintiffs. Then onus comes on the shoulder. Onus comes on the shoulder of the plaintiff to remove all such suspicious circumstances also. Otherwise, your will go. That's I have given the decision made by Supreme Court. Once the suspicious circumstance is not dispelled, what will happen? Suspicious circumstance which is clouded over you, which is not dispelled by you, what will happen? You will lose. You will lose. And that is why section 75 is very clear. That is, court has to, when a matter of will comes to the court, it is the duty of the court to have an inquiry with respect to the life and circumstance when it is executed, and what is the extent of the property, and what is the circumstance of the beneficiaries, etc., etc. All those are coming under section 75. And now we come to, suppose some mistake happened. What will happen? In a will, some mistake is happened. What mistake? Mistake of misnomer with respect to name. With respect to name. For example, suppose in a particular case that is coming to you, where he says, sir, when the testator executed the will, he has given a property in my favor, and that is in my favor means the will, it is clearly stated that this property is bequeathed to son of John, whose name is Thomas. That is stated in the will executed by the testator. And now Thomas is not there. John has only one son. But his name is not Thomas. His name is some other. His name is Stephen. Such a will is brought to you. What will happen? By reading that will is being executed in favor of Thomas, son of John. Son of John comes to you and he says, sir, no Thomas as son of John. The name of son of John is Stephen. I am Stephen. Actually, property is bequeathed in my favor. So that is that we can see that it is a mistake. In such a case, section 76 is very clear. In such a situation, such a mistake has happened or misdescription happened, such an error shall not prevent the legatee to take effect. That means because Mr. John has only one son. Actually, what testator intended to give it to the son of John, none other than. So, son of John is not to Thomas, but to Stephen. So, in such a situation, Stephen is entitled to get the property as a propounder on the basis of the will executed in favor of Thomas, son of John. Actually, his name is Stephen. That is why section 76 is incorporated. Such mistakes may be coming because a testator who is writing it, ordinary man who is writing it, some mistake will be correct. In such situation, on the basis of that mistake alone, legatee should not be prevented from taking the property disposed on the basis of the will. Section 76 reads, where the words used in a will to designate or describe a legatee or class of legatee sufficiently show what is meant. An error in the name or description shall not prevent legatee from taking it. That means, so suppose some mistake is happened, but from the description it can be understood. From the description it can be understood. In such a situation, what actually intended by the testator can be inferred, can be presumed, by the court from the circumstances, and such a mistake will not bar the legatee to take the property which has been allotted to him by way of will. That is what is stated under section 76. And now we go to another mistake that may happen. That means some missing of some material words in the will. Missing of some material words in the will. Then section 77 states that even though such a material word is being omitted, it may be applied in the context. It may be applied in the context. Pangacha sir, I have been muted. Sir?
Yes, I can hear you, sir. I can hear you.
Sir, I have been muted by you. Okay.
No, that's by mistake. Just
okay, sir. So for example, suppose I am a testator. And I have got two daughters. And I am making a will. And that will, I state that 500 rupees to my elder daughter and 500 to my younger daughter. So that means to the younger daughter, I missed the word rupees, only 500. Only 500 is stated there. 500 what? 500 what? So in such situation, missing of that material word. So elder daughter, I have given rupees 500, and to the younger daughter, I have stated only 500. In such a situation, section 77 is giving power to the court to consider the second word as 500 rupees, even though if it is written only as 500. So that's an example given here. In such a situation, some material words are being omitted. Court is having ample power to infer that missing material words from the circumstances of the case. And another point that may arise, that means material part may be left by the testator. That means testator may be intending to bequeath a portion of the property, but that is not clearly stated in the description, but that can be identified from the entire wordings in the will, in such a situation, court cannot reject the will, considering it as erroneous. This will is error, and will can be rejected. No. Section 78 says that in such a situation, court has to consider the actual intention of the party, intention of the testator, from the entire description given in the will by the testator. Section 78, I shall read section 78. If a thing which the testator intended to bequeath can be sufficiently identified from the description of it given in the will, but some parts of the description do not apply, such a parts of description shall be rejected as erroneous, and bequest shall take effect. For example, I can show you an example. Suppose a testator has a bequeathed 20 cents land by way of a will. That is the will executed by him. And now it is come in evidence that even at the time of execution of the will, only 14 cents were available. Only 14 cents was available. That means 6 cents was acquired by government authority by way of land acquisition proceedings. That is happened. So on that point, this will is error, having some error. That means at the time when he executed the will, he had only 16 cents. Only 14 cents. But instead of 14 cents, he has stated it in the will as 20 cents. So what defendant will come? What defendant will bring to the court? He will bring the records. This is also happened in one of my case. That is now continuing. See, what they will do? They will bring all the records of acquisition and all the other details and encumbrance certificate, etc., showing that this testator had no 20 cents at the time of execution, and he had only 14 cents at that time. So this will is totally error. Total error. So such a will cannot be accepted. Such a will cannot be taken to consideration by the court. But section 78 says such a description shall be such a description. That means it is not so for description with respect to 6 cents. That can be rejected. That can be rejected. Entire will cannot be rejected in such situation. That means what actually intended by the testator at that time, what testator intended at the time of execution of the will is to give 14 cents because it was actually physically available there. But by way of mistake, this error crept in the will. And in such a case, section 78 is very clear. If such an error is happened in a particular will, that portion can be rejected, and remaining part of the bequest shall take effect. Remaining part of the will shall take effect, provided it is proved. That is very different. That will be coming at the in the last part of our class. So this is section 78. Even so, even though some mistake with respect to the description of the property, that is important. even though some mistake crept in the will with respect to extent of the property, and by reading the entire description, and it is found that some error crept in, court can reject that error alone, but court cannot reject the entire will. The part of the will on the basis of the extent of actual physical availability of the property, to that extent, court can allow the bequest. Bequest shall take effect എന്ന് പറയുന്നത്. Bequest shall take effect after rejecting the error. Error happened. That is also coming with respect to a will, and so all these are based on section 74. Section 74, that is simple words and no technical words, etc. And now coming to section 79 also. Section 79 also, that is also very important. That is more practical. That means from the reading of the description of the will, and several circumstances may exist. And so property available with respect to the will may be limited. So section 79 is a continuation of section 78. Section 79 is continuation of extension of section 78. That means if a property actually stated but extent is less, or property actually stated extent is more than that, in such case also court cannot reject the will. Court cannot discard the intention of the testator. I shall read section 79 also. If a will mentions several circumstances as descriptive of a thing which the testator intends to bequeath, and there is any property in respect of which all those circumstances exist, but bequest shall be considered as limited to such property, and it shall not be lawful to reject any part of the description as erroneous. That means, suppose, for example, suppose in a will, the testator is describing two properties. Two properties are being described in the will, and one property not existing. Has to be provided to the propounder. Then on that ground alone, court cannot reject the will. Court has to consider the entire descriptions made in the will, and if it is found that some description is error, some description is happened by way of error, that alone can be rejected by the court. Even in such a situation, court has no right to reject the entire will. So that is with respect to allotment of property by way of will, wherein the extent stated is not available to give to the propounder. In such situation, section 78 and 79 will come into operation. And on that point, we have got some more decisions. That is KLT 2019 volume 1. KLT 2019 volume 1. Page 3181. Page 3181. Baburaj versus State. If there is a unanimity among the, if there is a unanimity among the legal heirs and their names are in the will also, their names are in the will also, and in such a cases, if there is a any error with respect to the description of the property, that error can be rejected and there is no impediment for the propounders to execute a rectification deed by such persons as to correct the descriptions in the registered will, as to correct the descriptions in the registered will. One more point. AIR 1961, page 129, Rohit versus Tejas. Not justified to consider a will as void, not justified to consider a will as void merely because relationship of legatee, with the testator not stated in the will, Then another point, one more point. AR 1951 Supreme Court. AR 1951 Supreme Court. Page 103. Page 103. Ammal versus Raju Iyer. Ammal versus Raju Iyer. In the case of discrepancies or inconsistencies in a will with respect to the property or its extent, with respect to the property or its extent, the duty of the court is to find out the intention, that is to be gathered from the language of the document. That is to be gathered from the language of the document. So
I think we can conclude today, sir, and we can have a discussion now. Now it is 5 o'clock.
Okay.
So that there may be some discussion.
Okay, sir, I am very sorry because in the case of will, there is no other alternate.
Okay.
We'll continue next time, sir, because there may be some.
Anyway, excellent. Altogether 100 persons participated today.
Okay, sir. So we can arrange a class some other day. Okay.
Yes, sir, definitely, sir. Definitely,
Okay.
sir.
When I get a time, I shall contact Sankacha sir.
Yes.
MC.
Sir. Okay, sir. So now.
No. Yes, we can have that.
നമുക്കൊരു സ്ലൈറ്റ് ഡിസ്കഷൻ ആക്കാം. MC
Okay, sir.
ഞാൻ MC-നെ കണ്ടിട്ടില്ല. MC.
MCC.
Vijayakumar sir, ഒരു ഡൗട്ട്
സാർ പറഞ്ഞോളൂ സാർ.
പ്രൊപ്പോണ്ടർ വിൽ എക്സിക്യൂട്ട് ചെയ്യുന്ന സമയത്ത് പ്രൊപ്പോണ്ടർ ആ സമീപത്തൊന്നും ഇല്ല, പ്രൊപ്പോണ്ടർ ഇതിനെ കുറിച്ച് അറിയില്ല. അതേ സമയത്ത് അറ്റസ്റ്റിംഗ് വിറ്റ്നസ് ബോക്സ് കയറിയപ്പോ പറയുന്നു വിൽ എക്സിക്യൂട്ട് ചെയ്യാനുള്ള നറേഷൻസ് കൊടുത്തിരിക്കുന്നത് ഹസ്ബൻഡ് ആണ്, ഞാനല്ലാന്ന്, എക്സിക്യൂട്ടന്റ് അല്ലാന്ന്, ലെഗേറ്റി അല്ല, എക്സിക്യൂട്ടന്റ് അല്ലാന്ന് പറയുന്നു. അതായത് കത്രീനയാണ് വിൽ എക്സിക്യൂട്ട് ചെയ്തത്. കത്രീനെ എക്സിക്യൂട്ട് ചെയ്തതിന് കാരണം ജോൺ ആണ് പറഞ്ഞു കൊടുത്തത് വില്ലിൽ എഴുതാൻ ആവശ്യമായ കാര്യങ്ങളെന്ന് അറ്റസ്റ്റിംഗ് വിറ്റ്നസ് പറയുന്നു. അതായത് കത്രീന ഒപ്പിട്ടുന്നതേ ഉള്ളൂ, കാര്യങ്ങളൊക്കെ പറഞ്ഞു കൊടുത്തത് ഭർത്താവാണ് എന്ന് അറ്റസ്റ്റിംഗ് വിറ്റ്നസ് പറയുന്നു. അങ്ങനെ നറേഷൻസ് വേറൊരാൾ പറഞ്ഞു കൊടുത്ത എക്സിക്യൂട്ട് ചെയ്ത വില്ലിന്റെ വാലിഡിറ്റി എന്താണ് എന്റെ ക്വസ്റ്റ്യൻ. അതിന് വല്ല റൂളിംഗ് ഉണ്ടോ? അതായത് ഡോക്യുമെന്റ് വില്ല് എക്സിക്യൂട്ട് ചെയ്യാൻ ആവശ്യമായ ഡീറ്റെയിൽസ് ആക്ച്വലി എക്സിക്യൂട്ടന്റ് അല്ല ചെയ്യുന്നത്, ഹസ്ബൻഡ് ആണ് പറയുന്നത്.
ഓക്കെ സാർ, മനസ്സിലായി. ലാസ്റ്റ് തന്ന 51 സുപ്രീം കോടതി ഡിസിഷൻ, അതിനകത്ത് ഇപ്പൊ പറഞ്ഞില്ലേ, AR 1951 സുപ്രീം കോടതി
പേജ് 103.
103. അതിനകത്ത് അതായത് അറ്റസ്റ്റിംഗ് വിറ്റ്നസ്, അതായത് ഈ എക്സിക്യൂഷൻ സംബന്ധിച്ചുള്ള ഉപദേശങ്ങളോ എന്തെങ്കിലും കൊടുത്ത് സംബന്ധിച്ച് അറ്റസ്റ്റിംഗ് വിറ്റ്നസ് orally stated something that will never affect the execution of the will and the court has to consider the intention.
പക്ഷെ
Intention
അവിടെ
of the
ആരും വേറെ ആരും തന്നെ ഈ ബില്ല് എക്സിക്യൂട്ട് ചെയ്യാൻ വേണ്ടി ആവശ്യമായത് കത്രീന പറഞ്ഞു കൊടുത്തെന്ന് പറയുന്നില്ല.
oh,
ഈ കത്രീന എക്സിക്യൂട്ട്
okay,
ദി ബിൽ. കത്രീനക്ക് പകരം ജോൺ ഹസ്ബൻഡ് ആണ് ബില്ലിന് ഡോക്യുമെന്റ് ഒരു ഡോക്യുമെന്റിനകത്ത് പറയേണ്ടുന്ന കാര്യങ്ങളൊക്കെ എന്റെ ഇത്ര എക്സ്റ്റന്റ് പ്രോപ്പർട്ടി, എന്റെ ഇന്ന ആധാരപ്രകാരമുള്ള പ്രോപ്പർട്ടി ഞാൻ ഇന്നയാൾക്ക് കൊടുക്കുന്നു എന്ന് പറഞ്ഞിട്ട് ഒപ്പിട്ട് കൊടുക്കുന്നത് ഒഴിച്ച് അത് ഡോക്യുമെന്റേഷൻ ചെയ്യാൻ ആവശ്യമായ എൻറ്റയർ ഡാറ്റ കൊടുക്കുന്ന അവരുടെ ഹസ്ബൻഡ്. അതാണ് എവിഡൻസ്.
മനസ്സിലായി. പക്ഷെ അവിടെ സാറ് അവിടെ ഉപദേശം കൊടുക്കുന്നതിൽ പ്രശ്നങ്ങളില്ലല്ലോ. ഉപദേശം കൊടുക്കുന്നതിൽ എന്താ പ്രശ്നമുള്ളത്? ഇവിടെ ചോദ്യം എന്താ? ഇവിടുത്തെ ക്വസ്റ്റ്യൻ എന്താണ്? അത് നമ്മൾ സെക്ഷൻ 68 സാറിന് അറിയാം. സാറിന് സോ മച്ച് എക്സ്പീരിയൻസ്. ഞാൻ പറയുന്നത് ഇവിടത്തെ ക്വസ്റ്റ്യൻ whether the testator was physically and mentally fit. So whether he has intended it, and whether the attesting witness has attested and made it due attestation also. That alone is the.
ഇത്തരത്തിലുള്ള വല്ല റൂളിങ്ങും കമ്മക്രോസ്
to the point എന്റെ അറിവിൽ വന്നിട്ടില്ല. പക്ഷെ എങ്കിലും മിക്കവാറും എല്ലാ കേസുകളിലും സ്ഥിതി ഇതാണ്, ഇന്റൻഷൻ.
അല്ല സാർ, ഞാൻ 24-ാം തീയതി 24th ഒരു ആർഗ്യുമെന്റ് ഉണ്ട്, അതിനുള്ള എന്റെ ഒരു പ്രശ്നം
ഉണ്ട്. ഞാൻ കാര്യം ചെയ്യാം സാർ, 24-ാം തീയതി
24th എന്റെ ഒരു ഹിയറിംഗില് എനിക്ക് മെറ്റീരിയൽ ആയിട്ട് കിട്ടിയത് ഇത്രയേ ഉള്ളൂ ക്രോസിൽ. അതുകൊണ്ടാ.
ഓക്കെ സാർ, ഓക്കെ സാർ. എങ്കിലും കിട്ടുമെങ്കിൽ ഞാൻ നോക്കാം സാർ. അല്ല, രാമേന്ദ്ര സാറ് അത് കംപ്ലീറ്റ് നോക്കി വെച്ചേ. പ്രത്യേകിച്ച് ആർഗ്യുമെന്റിന് വേണ്ടി നോക്കി വെച്ചേക്കാണ് മുഴുവൻ.
അല്ല, ആർഗ്യുമെന്റ് നോട്ടറിക്ക് അടിച്ചു, പക്ഷെ ഈ ഒരു പോയിന്റ് ഒന്നും കിട്ടിയിട്ടില്ല.
വിജയാട്ടനില്ലേ?
There is one question in the chat box, sir. That is it necessary that the building situated in the landed property to be evaluated through a government approved evaluator and its value also mentioned in the will? Sir, please clarify the point of mentioning the value of the shop also in the will before it is executed through.
With respect to question of will, there is no question of valuation.
Exactly. Okay.
There is no question of valuation at all.
Okay.
Simply we can take white paper and write it and attest it. That alone is sufficient.
നമ്മളെ വിജയകുമാർ സാർ ഉണ്ടല്ലോ, കെ വിജയകുമാർ
സാറിനെ കണ്ടില്ലല്ലോ ഒന്ന്. വിജയകുമാർ സാർ
ഉണ്ട്, ഇവിടെ ഉണ്ട്. വിജയകുമാർ സാർ ഉണ്ട്.
Let me check.
നേരത്തെ ഞാൻ കണ്ടു.
സർ, ഞാന് വേണുവക്കീൽ ഒരു ഡൗട്ട് ചോദിക്കാനുണ്ട്, കണ്ണൂർ.
പറഞ്ഞോളൂ സാർ.
ഞാന് സപ്പോസ് എ പാർട്ടി അപ്രോച്ചിങ് എ ലോയർ ഫോർ an advice to purchase a property.
Yes.
The property has to be purchased from A, for example. A acquired the property as per a sale deed of 2010, for example. A got the property by way of a sale deed of 2005 from B. So the property has to be purchased from A. A got the property from B in the year 2005. Then before those two documents, there involves a will. That means the present existing two prior deeds are okay sale deeds, but the third prior deed was a will, totally a will, which never involved in any legal proceedings. So there doesn't arise any question of proof of that will also. Can we safely advise a party to purchase such a property? The will is of the year, for example, the will is of the year 2000. In the year 2002, the testator died. So the property devolved upon the legatees. The legatee transferred the property in 2005 to somebody, to B, and B thereafter transferred the property to A in the year 2010. So two prior deeds are absolute same, but the third one was a will. Is it safe to give an advice to a client for purchasing such a property in which a will is involved as the third or fourth prior deeds? What will be the, or what are the precautions to be
Okay,
taken?
sir, okay, sir. So in
Okay,
such
sir.
a
Okay.
case-
Question
in
is
such
over.
a case- Okay, sir. In such a, your case is that your client want to purchase the property from A. A obtained the property from B, and B got the property by way of a bill. Isn't it, sir?
Yes, yes, yes.
Yes. So here, my suggestion is that if your party comes to you, you say, sir, you have to say to your client that since there is a will, the law relating to will is position is this.
Yes,
Unless or until that will is proved,
yes,
that will go.
yes,
And once the will is gone, the original legal heirs will get the property.
yes.
So by understanding that
Yes.
aspect and by understanding fully that you can purchase it.
Yes,
And if you are very confident that no other person will come with challenging the will,
yes,
definitely you can do it.
yes.
Otherwise, this problem is there. That
Yeah.
also you have to disclose, sir.
Yeah, yeah.
That is, sir, you are
Yeah,
hearing?
exactly. That is the position also we have understood.
Yes, sir.
Yes, nothing else can be given to the party concerned.
No, we cannot because
Is it so?
suppose
Is it so?
even
Yes.
30 years old document
Yes,
will
that
not
is
get
not
the benefit.
that is not
That-
applicable to wills. അല്ലേ?
Yes,
Will.
wills. ചെയ്യുമെന്ന് പറഞ്ഞുകൊണ്ട് ഈ അടുത്തിടെയൊക്കെ ഓരോന്ന് വന്നിട്ടുണ്ട്. പക്ഷെ അതെല്ലാം നിൽക്കില്ല because it will go. 30 years
Oh.
benefit.
So
that will not-
a transfer of a property involving a will always be a
Yes.
risky one.
Yes, risky one. That
Unsafe.
we are all coming to that point in
Quite
our
unsafe. Yes,
in
yes.
our later classes. നമ്മൾ അതിലേക്കൊന്നും വന്നിട്ടില്ല. നമ്മള്
Yes.
ഇപ്പോ ഡിസ്ക്രിപ്ഷൻ സ്റ്റീലൊക്കെ എത്തിയിട്ടുള്ളൂ. നമ്മള്
Okay, sir. Okay, thank you, sir.
Now Boban can ask. Boban.
സാർ ഒരു സംശയം.
Boban, you can ask.
അപ്പം
Boban.
ഹലോ ഗോവൻ സാർ
സാർ
പറയൂ.
അപ്പൊ ഗർഭിണി ആയിരുന്ന സമയത്ത് കുട്ടിയുടെ പേരിൽ അപ്പൂപ്പൻ വസ്തു വിൽപ്പത്രപ്രകാരം എഴുതി വെച്ചു. ഈ കുട്ടി ജനിച്ചതിന് ശേഷം രക്ഷകർത്താക്കൾ ആ കുട്ടിയുടെ ബെനിഫിറ്റിനാണെന്ന് പറഞ്ഞുകൊണ്ട് വസ്തു ട്രാൻസ്ഫർ ചെയ്തു. ഇപ്പൊ മേജർ ആയതിനു ശേഷം ആ കുട്ടിക്ക് ആ ട്രാൻസ്ഫർ ഡീഡ് സെറ്റിസ്ഫൈഡ് ചെയ്യാൻ കഴിയുമോ? കേൾക്കാമോ സാറേ?
Okay, sir. With the permission of the court. So that property was transferred with the permission of the court.
No, without permission of the court.
Then definitely when he became major, he can challenge it.
Sir.
Definitely he can challenge it.
കുട്ടിയുടെ ബെനിഫിറ്റിനാണെന്ന് പ്രത്യേകം
No, they should have that. No, sir. No, not for return. They should have approached the district court and get a permission to sell it and deposit entire amount before the court for the, if it is done for the benefit, that everything should be done. Without doing that, if the property of the minor is disposed, he is entitled to get it set aside after he is getting majority, and that should be done within 3 years after getting majority.
Yes, sir. Thank you, sir. Thank you. Yeah.
Okay, Srinarayan Unni. Can you hear me?
Okay.
Yes.
How do you, what is the quality of proof required for the second will, unregistered will? Quality of proof.
Sir,
Those are my-
okay, sir. Tell me, sir. Tell me.
Quality of
Complete your
proof.
questions.
What is the quality of proof required for an unregistered will?
Sir,
And there are-
quality. Sir, can you
Quality-
hear me, sir? Can you hear me, sir?
I can hear.
Okay, sir. So
There
quality of proving registered will and unregistered will, there is no difference.
Unregistered will.
Yes, quality of proving whether registered will
Yes.
and unregistered will, no difference at all. Whether it is registered will or whether it is unregistered will, you have to prove it. Due execution is to be proved. That can be done by examining one of the attesting witnesses. One of the attesting witnesses has to depose before the court that he has seen the testator executed it, and the testator has seen he has put the signature as the attesting witness.
Okay, so we can dispute the circumstances. Okay, we can dispute the circumstances.
Definitely,
we can dispute the.
Definitely, we can dispute it. That can be disputed. That is even in the case of registered will, that can be disputed.
Okay. Thank you, sir.
Thank you, sir.
Any other questions?
Tangachan.
Yes.
Vijayakumar
Vijayakumar sir illa no.
Vijayakumar, you can ask. Vijayakumar. Yes.
Sir, ഒരു പാർട്ടീഷൻ സൂട്ടില് ഒരു ബ്ലൈൻഡ് ലേഡിയാ, ഇളയ മകള് ബ്ലൈൻഡ് ലേഡി. അപ്പൊ അച്ഛൻ മകൾക്ക് വീടും പറമ്പും കൊടുത്തു. ഡിസ്ക്രിപ്ഷനില് ബൗണ്ടറി ഇല്ല, എത്ര സെന്റ് എന്നില്ല. പാർട്ടീഷൻ സൂട്ട് ഫയൽ ചെയ്തു, ഇപ്പൊ ബില്ല് പ്രൂവ് ചെയ്തു. അപ്പൊ അത് കോടതി എത്ര സെന്റ് കൊടുക്കും? ബ്ലൈൻഡ് ലേഡിയാണ്.
ഡിസ്ക്രിപ്ഷനിൽ പറഞ്ഞില്ല, പക്ഷേ
ബൗണ്ടറി ഉണ്ട്, പക്ഷെ അതിരളവില്ല, അളവുകളില്ല. ഇല്ല. ഹി മേ ബി ആൻ ഇല്ലിറ്ററേറ്റ് പേഴ്സൺ. അച്ഛനൊരു വിദ്യാഭ്യാസം ഇല്ലാത്ത ആളെ വീടും പറമ്പും മകൾക്ക് കൊടുക്കണം. ബ്ലൈൻഡ് ലേഡി.
ഇല്ലിറ്ററേറ്റ് ആയിട്ടുള്ള അവസ്ഥ അതുകൊണ്ട് സെക്ഷൻ 74 ഇൻകോർപ്പറേറ്റ് ചെയ്തിരിക്കുന്നത്. 74 അതുകൊണ്ടാണ് വന്നിരിക്കുന്നത്. അപ്പൊ അതിനകത്ത് ബൗണ്ടറീസ് ഇല്ല, അതായത് എക്സ്റ്റെൻഡ് പറയുന്നില്ല എങ്കിൽ ദ എക്സ്റ്റെൻഡ് ഓഫ് ദ പ്രോപ്പർട്ടി വിച്ച് ഈസ് കമ്മിങ് വിത്തിൻ ദ ബൗണ്ടറീസ് ഈസ് ദ പ്രോപ്പർട്ടി. സെറ്റിൽഡ് പ്രശ്നം അതാണല്ലോ മാഡം. ആസ് ദർ ഈസ് ഡിസ്പ്യൂട്ട് വിത്ത് റെസ്പെക്ട് ടു എക്സ്റ്റെൻഡ്, ബൗണ്ടറീസ് വിൽ എക്സ്റ്റെൻഡ് ആൻഡ് ഡിസ്ക്രിപ്ഷൻ, ബൗണ്ടറീസ് വിൽ പ്രിവെയിൽ.
ബൗണ്ടറി അതിരളവില്ലെങ്കിലും ആ ബൗണ്ടറി വെച്ചിട്ട്
4 വശം പറയുന്നുണ്ടല്ലോ.
4 വശം ഇന്ന പ്രോപ്പർട്ടി എന്നേ പറയുന്നുള്ളൂ. അപ്പൊ അത് എക്സ്റ്റെൻഡ് പറയുന്നില്ല സർ.
ഇതേ പറ്റൂ. എക്സ്റ്റെൻഡ് പറഞ്ഞില്ലെങ്കിലും ഇന്റൻഷൻ ഓഫ് ദ ഇന്റൻഷൻ നമ്മൾ പറഞ്ഞു, ആ ഡിസിഷൻ ഞാൻ തന്നു. ഇന്റൻഷൻ ഓഫ് ദ ടെസ്റ്റേറ്റർ വിൽ നോട്ട് ഗോ ഈവൻ ഇഫ് ദ പ്രോപ്പർട്ടി ഈസ് ലെസ് ദാൻ വാട്ട് ഇന്റൻഡഡ്.
അതെ.
Court can reject that part. Court can reject that part alone. Court can take the bequeath to that extent alone.
അങ്ങനെ ചെയ്യാം. പിന്നെ ഒരു വില്ലില് ഓക്കെ, അത് ക്ലിയർ ആണ്. പിന്നെ ഒരു വില്ലിൽ ഒരു പഞ്ചായത്ത് പ്രസിഡന്റ് ആണ് വിറ്റ്നസ്, മറ്റേ വിറ്റ്നസ് ഡൈഡ് ആണ്. അപ്പൊ ഈ പ്രസിഡന്റ് പറയുന്നത് ബോക്സ് കയറിയിട്ട്, ഞാനൊരു മീറ്റിങ്ങിന് വന്ന സമയത്ത് എന്നെ വന്ന് വിളിച്ചു, ഞാൻ പോയി ഏതോ ഒരു ഓഫീസിൽ പോയി ഒപ്പിട്ടു. ഇതിനകത്തുള്ളത് എന്താന്ന് എനിക്ക് മനസ്സിലായിട്ടില്ല.
അയാൾ അറിയണമെന്നില്ല.
വിജയകുമാർ സാർ മുന്നേ പറഞ്ഞിട്ടുണ്ട്.
അറ്റസ്റ്റിംഗ് വിറ്റ്നസിന്
അറിയേണ്ട ആവശ്യമില്ല. ഓക്കെ, അതെ, അത് മതി. ശരി.
വയനാട് നിന്നുണ്ടല്ലോ നമുക്ക് പുതിയ അതിഥികളൊക്കെ ഉണ്ട്. വയനാട് അരവിന്ദാക്ഷൻ തോമസ്.
എന്തെങ്കിലും ചോദിക്കാനുണ്ടോ തോമസ്?
തോമസ് MC രാമേന്ദ്രൻ, ഗുജറാത്തിൽ നിന്ന് നളിനി ജഡേജ ഉണ്ടായിരുന്നു കുറെ സമയം. ഇപ്പൊ
ഞാൻ കണ്ടിരുന്നു.
നളിനി ജഡേജ ഉണ്ടായിരുന്നു.
കണ്ടിരുന്നു.
ഗുജറാത്ത് സ്റ്റേറ്റ് സെക്രട്ടറി ഉണ്ടായിരുന്നു.
അതെ.
വേറെ ഇനി
തോമസ് ഒക്കെ എന്തെങ്കിലും ചോദിക്കാനുണ്ടോ?
തോമസ് റേഞ്ച് കുറവാണോ അവിടെ?
വയനാട്ടിൽ റേഞ്ച്
റേഞ്ച് ഇടയ്ക്കിടയ്ക്ക് റേഞ്ച് വിട്ടു പോകുന്നുണ്ട്.
ചോദിക്കാനുണ്ടോ? വിജയകുമാർ സാറ് ഉണ്ട്.
ഇല്ല, വളരെ നല്ല ക്ലാസ് ആയിരുന്നു. നല്ല ക്ലാസ് ആയിരുന്നു. അതെ. ഓക്കെ.
ലതാ തങ്കപ്പൻ വക്കീല് ഉണ്ടല്ലോ.
ലതയുണ്ട്.
Lata is my classmate. We are all classmates.
Okay.
I think now she is not there.
ഷർഫുദ്ദീൻ വക്കീൽ ഉണ്ടല്ലോ ഇപ്പം? ഇല്ല ഇപ്പൊ ഉണ്ട്. ഷർഫുദ്ദീൻ വക്കീലുണ്ട്. ഷർഫുദ്ദീൻ വക്കീൽ അൺമ്യൂട്ട് ചെയ്യൂ.
രാകേഷ് ചോദിക്കാനുണ്ടോ? രാകേഷ്.
സാർ, എനിക്കൊരു ഡൗട്ട് ഉണ്ടായിരുന്നു.
പറയൂ രാകേഷ്.
സാർ, എന്റെ അടുത്ത് വന്നൊരു കേസാണ്. അപ്പൊ അതിൽ എങ്ങനെയാന്ന് വെച്ച് കഴിഞ്ഞാൽ പാർട്ടി ഒരു കോൺട്രാക്ടർ ആയിരുന്നു. അപ്പൊ ഗവൺമെന്റ് കോൺട്രാക്ട്സ് ഒക്കെ എടുത്തെടുത്തുന്ന ഒരാളായിരുന്നു. അപ്പോൾ അതിനു മുമ്പ് ഈ ഡ്യൂ എമൗണ്ട് കിട്ടണേക്കാൾ മുമ്പ്, ഗവൺമെന്റിൽ നിന്ന് ഡ്യൂ എമൗണ്ട് കിട്ടണേക്കാൾ മുമ്പ് അദ്ദേഹം മരിച്ചുപോയി. അപ്പൊ അതിനോടൊപ്പം തന്നെ ഒരു വില്ല് എഴുതിയിരുന്നു. അതിലൊരു പവർ ഓഫ് അറ്റോർണിനെ ഏൽപ്പിച്ചിരുന്നു. ഗവൺമെന്റിൽ നിന്ന് കേസ് നടത്തിയിട്ടുള്ള ഈ ഡ്യൂ എമൗണ്ട് അയാൾക്ക് കൊടുക്കണമെന്നും ബാക്കിയുള്ള സ്വത്തുക്കളും ബാക്കി കിട്ടുന്ന എമൗണ്ട് മക്കൾക്ക് ഇത്ര വെച്ച് വീതിക്കണമെന്നും ഉണ്ടായിരുന്നു. പക്ഷെ അതിനോടൊപ്പം തന്നെ ആ വില്ലിലൊരു ക്ലോസ് ഉണ്ടായിരുന്നു. ലൈക്ക് എന്റെ ഈ കേസ് നടത്തുന്ന വക്കീൽ, ആ വക്കീലിന്റെ പേരും സ്പെസിഫൈ ചെയ്തിരുന്നു. എന്റെ ഈ കേസ് നടത്തുന്ന വക്കീലിന് ഈ തുകയിൽ നിന്ന് ഇത്ര ലക്ഷം രൂപ കൊടുക്കണം എന്ന് പറഞ്ഞിട്ട്. അപ്പൊ അതൊരു അതെ, അപ്പൊ അത് കുറെ നാളായിട്ട് നടക്കുന്ന ഒരു കേസാണ്. അപ്പോ ആ വക്കീല് വക്കാലത്ത് റിലിംഗ്വിഷ് ചെയ്തു. അപ്പൊ ഇപ്പോ ആ കേസ് നടന്നുകൊണ്ടിരിക്കണുണ്ട്. അപ്പോ ഇപ്പൊ അനുകൂലമായിട്ട് വിധി വരികയാണെങ്കിൽ ആ വില്ലിലുള്ള ആ ഒരു വക്കീലിന്റെ ആ ഒരു ക്ലോസ് അത് സ്റ്റാൻഡ് ചെയ്യോ എന്നുള്ളതാണ്.
കാരണം വക്കാലത്ത് കൊടുത്ത ആളാണോ അല്ല പുതിയ ആൾക്കാണോ?
അല്ല, അത് ഭയങ്കര സംശയം തോന്നിയതാ. കാര്യം ഞാൻ നേരത്തെ നിന്നിരുന്ന ഓഫീസില് വന്നൊരു കേസായിരുന്നു അത്. അപ്പോ അതില് ഇ പി സ്റ്റേജില് ഇപ്പൊ ഞാൻ ആ ഓഫീസ് മാറി. അപ്പൊ എനിക്ക് അതിന്റെ ഔട്ട്കം എന്താന്ന് ശരിക്കും പറഞ്ഞാൽ അറിയില്ല. ബട്ട് ഈ ഒരു ക്വസ്റ്റ്യൻ എന്റെ മൈൻഡിൽ നിൽക്കണ്ടായിരുന്നു, ഹൗ വിൽ ഇറ്റ് എഫക്ട് എന്നുള്ളത്. അതെ, ആക്ച്വലി അല്ല, അൺരജിസ്റ്റേർഡ് വില്ലായിരുന്നു.
അതായിക്കോട്ടെ, അതിലൊന്നും പ്രശ്നമില്ല. അൺരജിസ്റ്റേർഡ് ആ ക്വസ്റ്റ്യൻ ഇല്ല ഇവിടെ. അൺരജിസ്റ്റേർഡ് ഓർ രജിസ്റ്റേർഡ് ക്വസ്റ്റ്യൻ ഇല്ല ഇവിടെ. വേറെ ഡ്യൂ എക്സിക്യൂഷൻ നടന്നിട്ടുണ്ടോ അതിനകത്ത് കണ്ടീഷൻ വെച്ചാൽ ആ കണ്ടീഷൻ വേണമെങ്കിൽ വേറെ കേസിന് പോകണം. അതുകൊണ്ട് ആ കണ്ടീഷൻ കംപ്ലൈ ചെയ്യില്ല എന്ന് കരുതിയിട്ട് അടുത്ത ക്ലാസ്സിൽ കിട്ടും അതിന്റെ ഡിസിഷൻസ് ഒക്കെ. അടുത്ത് വരുന്ന ക്ലാസ്സിൽ വരുന്നുണ്ടല്ലോ. ആ കണ്ടീഷൻ കംപ്ലൈ ചെയ്തില്ല എന്ന് കരുതിയിട്ട് വിൽ നോട്ട് ഗോ.
അല്ല, വക്കീലന്മാർക്ക് നല്ലത് വില്ല് വഴിയുള്ള ഫീസ് ഒഴിവാക്കുന്നതാണ്.
തങ്കച്ചൻ, ചന്ദ്രബാബു എന്തോ ചോദിക്കുന്നത്?
ചന്ദ്രബാബു, you can ask question now. Yes. നേരിട്ട് ചോദിച്ചോളൂ ചന്ദ്രബാബു. കേൾക്കുന്നില്ല, വോയിസ് കിട്ടുന്നില്ല ചന്ദ്രബാബു. ചാറ്റ് ബോക്സിലുണ്ട് ചോദ്യം സാറേ, ചാറ്റ് ബോക്സിലുണ്ട് ചോദ്യം.
ഞാൻ ചാറ്റ് ബോക്സ് നോക്കുന്നില്ല, അതുകൊണ്ടാണ്.
ചാറ്റ് ബോക്സ് ഞാൻ പറഞ്ഞുതരാം.
വായിച്ചോളൂ.
A having 5 properties.
Chat box il endho ittundallo.
A is having 5 properties P, Q, R, S, T. A executed a will in the year 1995 concerned to the property P, Q, R, S in favor of B, C, D. In the year 2000, he executed another will concerned to the property R, S, T in favor of C, D, F. He has not cancelled the previous will. Which will is having legal validity? That two will execute it. That is interest.
അതിന്റെ ഡയറക്റ്റ് ഡിസിഷൻ ഞാൻ തന്നു. ഡയറക്റ്റ് ഡിസിഷൻ ഞാൻ തന്നു. അതിനകത്തുള്ള സംഭവം എന്ന് വെച്ചാല് സെക്കൻഡ് നോർമൽ കോഴ്സിൽ സെക്കൻഡ് വിൽ പ്രിവെയിൽ ബിക്കോസ് once the second will is executed, that itself shows evocation of the first will. But thing is that second will should be proved. Second will should be proved. Then only revocation will come into existence. If the second will is not proved, then earlier position will come into effect. Okay, Chandrababu sir.
Chandrababu, still we cannot hear you. Still you are not audible now.
എന്റെ മൈക്കിന് പ്രോബ്ലം ആണ് ചന്ദ്രബാബു. എന്തോ മൈക്കിൽ എന്തോ പ്രോബ്ലം ഉണ്ട്.
എല്ലായിടത്തും മഴയൊക്കെ ആയതുകൊണ്ട് പ്രശ്നങ്ങളാണ്. ഞാൻ വിചാരിച്ചു നമ്മുടെ ക്ലാസ്സിൽ നിന്ന് ഇന്ററപ്റ്റ് ആവുന്നുണ്ടോ.
അതെ അതെ, പക്ഷേ
ഭയങ്കര മഴ.
കുഴപ്പമില്ല, വലിയ കുഴപ്പമില്ലാണ്ട് പോയി. അങ്ങനെയാണ്. തങ്കച്ചൻ, വേറെ ഗിരീന്ദ്രബാബു എന്തെങ്കിലും നമുക്ക് ആഡ് ചെയ്യാനുണ്ടോ?
ഗിരീന്ദ്രബാബു ഉണ്ട്, സുരേഷ്, എല്ലാരും ഉണ്ട്, ആൾക്കാരൊക്കെ ഉണ്ട്. ഗിരി,
സുരേഷ്
ഒന്നുമില്ല.
ഇതാ നളിനി ജഡേജ. മാഡം ഒന്ന് അൺമ്യൂട്ട് ചെയ്യോ? നളിനി ജഡേജ.
അവർ മൈക്ക് വർക്ക് ചെയ്യുന്നില്ല.
അതെയോ?
മൈക്ക് ഓഡിയോ ഇല്ല, ഓഡിയോ വീഡിയോ മാത്രമേ ഉള്ളൂ.
ഓക്കെ ഓക്കെ ഓക്കെ. നമ്മൾ പറയുന്നത് കേൾക്കുവോ?
കേൾക്കില്ല, കേൾക്കാൻ പറ്റില്ല. ഓഡിയോ കണക്ട് ചെയ്തിട്ടില്ല, നമ്മൾ ചിത്രം മാത്രമേ കാണുന്നുണ്ടാവുള്ളൂ. സുരേഷ് ഇപ്പൊ ഇല്ല, സുരേഷ് പോയി. കൺക്ലൂഡ് ചെയ്യാം.
കൺക്ലൂഡ് ചെയ്ത് തങ്കച്ച, എന്നിട്ട് കൺക്ലൂഡ് ചെയ്തിട്ട് എനിക്ക് തോന്നുന്നു വേണു വക്കീലില്ലേ? വേണു വക്കീല് ഒരു നന്ദി പറയാൻ വേണ്ടിട്ട് വിളിക്കോ?
ഷിജിൻ എന്തോ ചോദിക്കണം. ഷിജിൻ പ്ലീസ് അൺമ്യൂട്ട് യുവർ സെൽഫ്. യെസ്, ഷിജിൻ ചോദിച്ചോളൂ. ഷിജിൻ കേൾക്കുന്നില്ല, പറഞ്ഞോളൂ ഷിജിൻ. ഹലോ,
ഓഡിയോ പ്രോബ്ലം ഉണ്ട്. നമുക്ക് അങ്ങനെയാണ് ഒരു നെക്സ്റ്റ് ടൈമിലേക്ക് ചോദിക്കാം.
നമസ്കാരം, എല്ലാവർക്കും നമസ്കാരം. എസ്പെഷ്യലി വിജയകുമാർ സാറിന്. ഇത്രയും ഡീറ്റെയിൽ ആയിട്ട്, ഇത്രയും വളരെ വിശദമായിട്ട് എക്സ്പ്ലെയിൻ ചെയ്തിട്ടുള്ള ഒരു ക്ലാസ് വളരെ നന്നായിട്ടുണ്ട്. എസ്പെഷ്യലി ഓൺ ദി ടോപ്പിക് ഓഫ് വില്ലിനെ കുറിച്ചിട്ടൊക്കെ അങ്ങോട്ട് എന്താ പറയണ്ട, ഒരു 69 ശേഷമുള്ള പോർഷൻസ് ഒന്നും സാധാരണ നിലയിൽ ആരും അങ്ങനെ ഒരു വിശദമായിട്ട് പരിശോധിച്ചിരിക്കാനും സാധ്യത കുറവാ. പക്ഷെ അതൊക്കെ വളരെ വിശദമായിട്ട് സാർ കവർ ചെയ്തു. എല്ലാവർക്കും വളരെ വ്യക്തമായിട്ട് നല്ല ഹൃദ്യമായ മനസ്സിലാകുന്ന തരത്തിൽ ഭാഷയിൽ സാർ അവതരിപ്പിച്ചു. എല്ലാവർക്കും വളരെ സാറ്റിസ്ഫൈഡ് ആയി എന്നാണ്. എനിക്ക് സാറ്റിസ്ഫൈഡ് ആയി, വെൽ സാറ്റിസ്ഫൈഡ് ആയി. അതുപോലെ തന്നെ എല്ലാവർക്കും സാറ്റിസ്ഫൈഡ് ആയി
എന്നുള്ളതാണ്.
അപ്പൊ ഇത്രയും നല്ല ക്ലാസ് സാറ് നടത്തിയതിന് ഓൾ ഇന്ത്യ ലോയേഴ്സ് യൂണിയന്റെ ജില്ലാ കമ്മിറ്റിക്ക് വേണ്ടി സാറിനോട് വളരെയധികം നന്ദി അറിയിക്കുകയാണ്. അതുപോലെ തന്നെ ഇന്നത്തെ ക്ലാസ്സിൽ നല്ലൊരു പാർട്ടിസിപ്പേഷൻ ഉണ്ടായിരുന്നു, എസ്പെഷ്യലി ഈവൻ കമ്പയറിംഗ് വിത്ത് അതർ ക്ലാസ്സസ്. എനിക്ക് തോന്നുന്നു ഒരു 70-ലധികം പോയി. എല്ലാവർക്കും കുറച്ചുകൂടി ആ ഇൻട്രസ്റ്റ് ഉള്ള ഒരു ടോപ്പിക്കും കൂടി ആയിരിക്കുമല്ലോ വില്ല് എന്നൊക്കെ പറയുമ്പോൾ. അപ്പോ നല്ലൊരു പാർട്ടിസിപ്പേഷനും ആയിരുന്നു ഈ ക്ലാസ്സിൽ. എനിക്ക് തോന്നുന്നു ഈവൻ ഫ്രം അതർ സ്റ്റേറ്റ്സ് ഓൾസോ ദർ വർ പാർട്ടിസിപ്പൻസ്. ഐ കം ടു മൈ ഡ്യൂട്ടി ഓഫ് expressing thanks to all the participants, including the today's the Sri Vijayakumar sir, who had given a very attractive and well talented class to all the participants. And I once again thanks Vijayakumar sir as well as all other participants to the today's class. Okay, sir.
Thank you sir, thank you. And before leaving, anyway, next class I shall inform Pankaj sir, because that is his continuation. Okay sir. Okay, thank you very much sir. Bye.
Thank you sir. Thank you so much. So let me conclude the session now.
Okay.
Closing the window. Okay. Bye.
Okay. Okay. Bye.